The 2004 tort reform was not passed by Republicans. It was a bipartisan effort. And that's important to keep in sight. And that was not an accident. I want to relate a very short story to you. In January of 2004, I was elected in 1999, and there were 33 Republicans in the House of Representatives. By January of 2004, when we came in after 2003 elections, we had somewhere in the mid-40s. We had made significant gains. Haley Barbour's coattails were fairly long, as you can imagine. We made significant gains. Well, a group of us went over to see the governor at the Woolfolk Building. Governor, you may remember, Sillars was still under repair at the time. A group of us went to the governor. We were anxious to organize formally a Republican caucus. We were in the minority, but we were a strong minority now. We wanted to do that. We thought the time was right. We sat down with the leader of our party, and he put the kibosh on it pretty quickly. You know, I'm a Nixon Republican, Governor, as you are. I was ready to organize. The governor was wise enough, and he didn't explicitly talk about tort reform, I don't believe, in that conversation. By the way, there are witnesses here. Jim Ellington was part of that group, Jim Simpson, Mark Formby, Bill Denny. I mean, we all went over there to sit down with Haley. He told us, no, we don't need to do that. And he had the wisdom to understand that, sure, we had 45 or so Republicans, but we had another 10, at least, another 10 solidly conservative Democrats who not only would vote for tort reform, they'd fight for it. They were elected on it, many of them, in 2003. In addition to that, the governor was smart enough to know that probably an additional 15 or so Democrats, where they weren't keen on tort reform and would frankly just as soon see it go away, they weren't prepared to kill it. And if we could get it to the floor, it was going to pass. Well, it didn't come to pass, as you know, in the regular session. And there's a reason for that. It's really the second point I want to make. First point is it was a bipartisan coalition that passed tort reform. I will say this, I agree with Governor Bryant. This is going to sound like a partisan statement, and it is. I'm chairman of the Republican caucus. I guess I'm entitled to make partisan statements, but it was a bipartisan effort to pass tort reform. It's going to be a Republican effort to save it in the legislature if we ever get to that point. The bipartisan coalition that we once had no longer exists because that group of conservative Democrats no longer exists. Most of them are the ones that are still in the legislature are Republicans. The ones that aren't are replaced by Republicans. So that's the reality we have now. And it's important to keep that in mind, as Governor Bryant mentioned. Second point I wanted to make, there's no accident that this was done in a special session. All right? People talk all the time, and rightly so, about how powerful the lieutenant governor is and how powerful the speaker is. Well, it's not because they hold a gavel. I mean, they even let me do that. You know, I do that fairly regularly. That's not where the essence of their powers derive. You might say, well, it's because they appoint the chairs, they appoint the vice chairs, they appoint the committee composition. They refer bills to committee. All that is extremely important, and that is the reason they are powerful. But the reason that undergirds that is because we have a system of rules and rigid deadlines, as the governor mentioned earlier, that in any legislative session, if a chairman is powerful enough, and most of them are, they can just let a bill die. And that's what happens in a regular session. We don't have those deadlines in a special session. It's like Groundhog Day every day. Everything's new again. You can't get away from there. The governor's not going to send you home, and that's why it had to be done in a special session. The 83-day tort reform special session in 2002 was probably my worst experience. About ruined me. I could show you my tax returns from 2002. You probably wouldn't believe it. It was terrible, spending 83 days away from my law practice. But it was necessary. In 2002, it was necessary. We didn't accomplish as much as we wanted, and the truth is, everyone went away, both sides went away from that session feeling unfulfilled and knowing there was further work to be done. And then the very next year, Haley Barbour runs for governor and puts it on everybody's plate in 2004. I would suggest to you this. I have racked my brain to try to think of another issue that something like this could happen again on. I don't think there's been another issue in the 15 years I've served in the legislature where the right combination, because a governor just being hard-headed and calling a legislature back and saying, we're going to stay here till you pass it, that's not going to work. It only works because you have the grassroots support back home. You have the business community, in this case the medical community, solidly behind it. People supported Governor Barbour holding the legislature there and putting their feet to the fire. And there was no escape. There was no escape. We had to pass tort reform because the public demanded it. And there were strong enough minorities in the House particularly insisting on it. And that's how it got done. And it was a combination of factors, Governor Barbour's leadership for sure, and the fact, again, as many people have pointed out, the people in this room who made that grassroots effort happen. But I'll say this again, you could not have done it in a regular session, in my opinion. Had to be done in a special session. That's my comments. I just wanted to kind of set the stage for that. I'm privileged to be here. We have a very, very fine panel. Thank you, Governor. We have a very, very fine panel. I'm going to invite next one of the heroes of that day and a hero to me ever since, former Senator Charlie Ross. You're next.
It was a great victory, but nothing is static in public policy and politics, and we have to look to the future. Much has been mentioned about the challenges that are percolating in the courts, and those are real challenges. In Florida, within the past few months, the 9 economic caps were struck down on a constitutional basis. Unfortunately, that has happened in some other states. Fortunately, in more states, it has been upheld. Mississippi has not addressed it, the Mississippi Supreme Court. The federal courts have, and they've handed down good decisions. But until the Mississippi Supreme Court upholds the 9 economic caps, that's a cloud hanging over the statute. I urge you, the business community, the professional community, the medical community, to do everything you can to ensure that the case for the constitutionality of those caps is upheld through amici briefs, hiring the best legal talent available, and being involved in judicial elections. I think that the caps will come up in the next year or two, but we don't know. So far, the Mississippi Supreme Court has managed to avoid ruling on them by deciding the cases on other grounds. It's important that we stay vigilant in that regard. There's another area that I think is very important going forward in the future. You have the substantive law, you have the juries, and I'm proud to say part of Mississippi tort reform, which hasn't been talked about much, but which is very important, was the Jury Patriot Act, which made it easier for people to serve on jurors who have demanding jobs, so that you have a cross-section of the community. And then you have the judges. I'm very proud of the current Mississippi legislature for passing a judicial pay raise, because we need talented people in the judiciary who think about the law, who are respectful of the law passed by the legislature, who don't want to make the law, but they want to interpret and apply the law. And to attract those talented people and to retain those talented people, we can't pay them as much as they would make in the private sector, but we need to pay them enough to where they have incentive to join the judiciary and stay there. Further, when you think about going forward, you have to realize that this is a process that takes time. That was true in 2004, is true today. 2004 happened in large part because Governor Barber made it a centerpiece of his campaign. And the people spoke. And when the people speak, the Mississippi legislature usually does what they say. But before that campaign, a lot of groundwork was done. I see Senator Dean Kirby over here. I can remember him holding committees in the Insurance Committee, joint committees with the House, 4 or 5 years before we passed tort reform. It was contentious, it was ugly, it was difficult, but that process was necessary to come up with, quote, tort reform. By 2004, you were either for it or against it, but you knew what it was. You knew tort reform had meaning, and that's because of that process. Now, I'm very proud of the fact that in 2004, I don't think we overreached at all. I think we were addressing real problems, rampant unpredictability in the system as to where you could be sued, how much you could be sued for, what activities you could be sued for. And it was not our goal, or at least it was not my goal as the chairman on the Senate side, to cripple the legal system. Instead, it was to make it better. The legal system is not the enemy of business and the medical profession and other professions. A bad legal system is the enemy of business and professionals, whether they be medical or otherwise. We need a good legal system, and I'm very proud to say we reformed the system, but I don't think we shut the courthouse door to anybody, and I don't think we deprived reasonable compensation to any legitimate claimant or plaintiff. Our goal was to make the system work, not to hamper the system. And a system that is fair and predictable will be accepted by the citizens of the state of Mississippi, whereas what we had in 2004, the public was ready to vomit it out of their mouth, and they actually did that in the election where the issue was presented to them full force. Going forward, I think we need to take the same approach. We're not an enemy of the legal system. We want to make it better. But if there are areas that need to be reformed, we will tackle them head on, without hesitation, with tenacity, and with courage. Do those areas exist? I'm proud to say the 2004 package was comprehensive. It cured most of the ills, in my judgment. Do some still exist? Yes. I've heard Governor Barber say, and I agree with him, the worst case of lawsuit abuse right now is Attorney General actions, where he sues on behalf of every citizen in the state of Mississippi against businesses, and there's no statute of limitations because the state is deemed the plaintiff. And in addition to compensatory damages and sometimes punitive damages, he seeks $10,000 per violation going back sometimes 15 or 20 years. And you can imagine $10,000 per violation if a violation is a retail sale of a pharmaceutical drug or something like that. The numbers add up quickly. And frankly, in my opinion, we have a situation much like in this small area, much like 2004, where the unpredictability creates jackpot justice and people settle not because they feel like they did anything wrong, but because they can't afford to take the risk of breaking the company with a rolling the dice. I'm very proud of what we accomplished. Diligence is important. I'm very confident in the current Mississippi legislature and the governor. I'm very confident in you. And that's the final point that I want to make. The reason this ultimately happened in 2004 was the election, and it was the business and the medical community saying, we're going to stand up for ourselves. We don't normally fool with the courts. That's normally something for lawyers and judges to deal with, sort of a closed society, but that changed in 2004. The people became involved, and that's the way it should be. The danger is that the people will give it back to the lawyers in the courts, and the lawyers in the courts are not bad people. I'm one of them. I'm proud to be a lawyer. But we are much better if the business community and the medical community stays involved. I encourage you to do so. It's important for the lawyers in the court. Most importantly, it's important for the people of Mississippi. Thank you, Greg.
To remember an afternoon, a very long afternoon, in Judiciary A with Representative Mike Mills as the chairman, now Judge Mills, trying to get a vote on House Bill 1270 on the Mississippi Product Liability Act, and the vote was 12-12. And there was one representative missing, who was rumored to be circling the Capitol in a car. So people left the room searching for the missing representative, and we sat there. And then somebody made a motion to adjourn, 12-12. Another vote called to the question, 12-12. We were there all afternoon, I think, Commissioner Cheney, and we couldn't even leave to use the restroom. But eventually we got a vote, and it came to the floor, and the Mississippi Product Liability Act eventually became law. Now, it really wasn't that big a deal at the time because it was just simply a codification of what lawyers call Rule 402A for product liability. But it was, in a sense, a big deal because it was one of those turning points. And only with the coming together of great leadership like Governor Barber, and all of the groups who finally brought all of those elements together in 2004, did we finally accomplish what we've been working on for so long. So my first point about the future is that tort reform is not a state of nirvana, it's a journey. It's something that continues. And if you want to go back even further, when I was a young lawyer getting out of law school in the mid-'80s, down on the Mississippi Gulf Coast, I don't know how many of you remember this, there were dozens of 3 Mile Island suits in the Southern District of Mississippi in Biloxi. Now you might think, well, gee, what were 3 Mile Island suits doing in Biloxi in 1988? The reason is because there was a 2-year statute of limitations in Philadelphia and in the states that surrounded 3 Mile Island. And guess where there was the only 6-year statute of limitations in the United States? Mississippi. So people flooded in to file those suits here. And that was going on all over Mississippi. So finally, the legislature did something about that. Then we came along in 1993 and had the Product Liability Act. And then we had joint and several liability reform in 1989, which wasn't really reform, as we all know, 2002, which wasn't really reform, till we finally got to where we needed to be in 2004. Again, trying to emphasize the point that this is a journey that still has to continue, that is not finished even to this day. So when we think about what the legislature can do, I'd like to think of it as, some folks have already alluded to this, that tort reform is really like, and the future of tort reform is a three-legged stool. It's the legislative portion that we're all familiar with that requires the changes to the law. Then it's the substantive portion in the courts that's required to hang on to what you have. Now, for those who might think that we're crying wolf about what could happen in the future, how about the old saying, past is prologue? Because with that great 1993 Product Liability Act, it only took 3 years for a court in the Northern District of Mississippi in a case called Taylor versus General Motors to gut it, basically. And just to kind of give you an example of what courts can do in a situation like that, when we were working on that act in 1993, the very first line of the bill says, in any action for damages caused by a product. In any action for damages caused by a product. And the federal judge, and again, this isn't necessarily in the Mississippi Supreme Court, it doesn't always occur there. A federal judge said, nah, they didn't really mean that, because you could still file a suit under a negligence theory or an implied warranty theory. So the Product Liability Act doesn't really apply to all these other cases. And then another court followed that in a case called Childs. And then it didn't take long, actually I guess closer to 20 years, for the Mississippi Supreme Court then to weigh in and say, well, it doesn't really apply to designers, and here we are again. Only with the last session of the legislature, House Bill 680, did it finally, the bleeding finally stopped, trying to get back to where we were in 1993. So the first part is legislative reform. The second part is vigilance with the courts to make sure that the reforms that are passed are maintained. And the third is, this is all part of the same process. The third is, and we don't really think about it this way sometimes, but reforms can actually take place in the courts themselves, tort reforms. Now, as important as the 2004 Act is, and it is, by the way, it is the most important tort reform measure ever passed in Mississippi, about that same time with Governor Barber's election, as we all know, the political climate changed in a lot of different ways, and our court reflected that change, the Supreme Court, because first of all, in a case called Janssen versus, it was a propulsive case, Janssen versus, and I can't remember the name of the drug company right now, but that was the case arising from Jefferson County, where remember all the mass torts where everybody joined together, the court said, well, under Rule 20, we're not going to allow that anymore. Boom, just like that. 5 members of the Supreme Court can make tort reform history. A case called Mangalardi that happened not too long after that, they said, you know what, we're not going to allow these big complaints that are filed against 100 defendants by hundreds of plaintiffs that don't even tell them what the case is about, these type of asbestos complaints. Boom, another piece of tort reform enacted by the Supreme Court is a nice way to think about it. And so the courts can be part of the problem, but they can also be part of the solution. And that's why it's so important as we move forward in the future to focus not only what we can do in the legislature, but what we can do in the courts. Thanks very much.
Thank you. And Governor, it's an honor to be here. When you have my job, most of the time you go to places around the country, it's because there are problems. It's because the courts, the legislatures, but usually it's the courts, have created significant problems. And it's really a pleasure for me to be here in Mississippi to celebrate your success. And I would just say, as a personal observation, that success begins with leadership, and that's your leadership. And others have followed, others continue, and your successor continues that, which is wonderful. Lex Taylor, who I've known for a long time, I would echo all the positive comments that are made about him and the leadership that he and numerous other individuals have provided as you've really righted the ship here on the legal system in Mississippi. My association is the one that coined the term judicial hellhole. We were the ones that observed, as the governor pointed out, the frequency of the filing of outside of the state plaintiffs and mass torts in that county, and how the lawsuits outnumbered the citizens. We talked about the Bankston pharmacy, reading stories about people going in to buy half a pill. I don't know, maybe sometimes half a pill is what you're supposed to take, but it seems kind of strange to me, although I'm not a doctor. Those are the kinds of things that give rise to that designation. And I think really what it shows more than anything was that the problems with the legal system in Mississippi, which really were focused in some particular areas, were really confined to just a few individuals. It was to the judges and the lawyers and the people who administered the system. And I think there was a recognition that the typical individual on the street, the consumer, the small business person, the physician, was really not a part of that process. Changing that dynamic was the most important thing that you did, so that people recognized they all had a stake in the legal system. And again, that comes back to the leadership. I was pleased and privileged to participate in your job summit before your tenure began. And it's been great for us to witness all that you've accomplished, to watch the success, to hear about the improvements. So I was flying down this morning reading in the Wall Street Journal in an editorial about Mississippi competing for a plant from an auto company. Something that I think those of you here have been saying that wouldn't have happened a decade ago. And I think that your success really points to that. The access to health care. This is really something that affects us all. It doesn't matter whether you're worth $1 billion or you're just a person struggling to make it. Everybody needs access to health care. At all ages and all stages, and you've accomplished that. So this is a great legacy. So we applaud that. We're happy to be here to celebrate that with you. With that, let me just offer a few thoughts. You've had a lot of very smart and well-informed speakers, and so I'm not going to repeat too much of what they said. But I think you heard the speaker talk about for the future the appeal bond issue. We see that as the one area in the current, if you think about it, as kind of a menu of issues where you got out front through the actions of your court, but I think we think more needs to be done. I was particularly very encouraged to hear Speaker Gunn talk about that, and we would strongly support following in the path of other states that have come since your reform was enacted, I believe, in 2001, or the policy change through your state Supreme Court. And you heard the statistics. I won't go through them, but even just think about the fact, as he pointed out, that 5 states don't even require these appeal bonds. The governor talked about how any business is just one lawsuit away from bankruptcy. That's absolutely true. It's even more the case when you think that you may have a strong defense, but you got an outlier type verdict. If you can't post the bond, you're in the same trouble even when the merits are on your side. So just think if you can think about it in those terms. Your courts, your statutes will be challenged. That's already going on. That's going to be an ongoing process. We see that all over the country. We heard mention of Illinois and in Ohio back in the late 1990s, where not just provisions of legal reform statutes, but entire statutes that were analogous to or of the same scope as your 2004 law were eliminated, one fell swoop, 4 to 3 opinions, 5 to 2 opinions, and the decisions and the policy judgments of legislators and governors simply just washed away in one fell swoop. So that's a risk you have to run. Charlie Ross was exactly right. You have to be attentive to the courts. You have to watch for these challenges. You have to be in a position to support the process support these statutes through the amicus process, and that's something that we would be right there with you in doing that if that's something that would be of assistance. So just recognize that that's inevitable. We were talking about it just a moment ago. As night follows day, that's what you're going to see. The last thing that I'll mention is really, again, is sort of builds a little bit on what Charlie Ross talked about with some of the particular lawsuits that you may see is a Consumer Protection Act, which looks and sounds great. It's good to protect consumers. Who's not for that? But these laws are very malleable. They are ill-defined in many instances, and we are seeing significant problems with them around the country. So in terms of something that's over the horizon, that's something to keep an eye on. And we hope that we will be in a position working with organizations around the country to help make them serve their appropriate purpose of protecting consumers, but not becoming a new avenue for litigation. So I'm pleased to be here again. Thank you so much for the invitation. And I congratulate not just Governor Barbour, but all of you for the great work that you've done, and it's an honor for me to be here with you. Thank you.